everyone, and welcome to another episode of At War, the podcast by the Conflict Law Center. Today, we are very happy to be joined by Dr. Rana Mostafa, who is an assistant professor of public international law at Alexandria University in Egypt. Thank you so much for joining us.
Thank you for having me.
We've been reading your articles with so much interest over here. So thank you so much for, bringing to light such important legal aspects of this conflict, which I think have been missed. But I wanted to start off by talking to you about the fact that just yesterday we had Israeli and Hamas leaders being indicted, an application for arrest warrants being issued by the prosecutor. And these arrest warrants have been limited to war crimes and crimes against humanity, including the crime against humanity of extermination. No genocide charges are there. What do you make of this? And how do you think it will affect South Africa's case at the International Court of Justice?
Okay. Yeah, so everyone was waiting for those arrest warrants to be issued. And I think that this is a very welcome step to fight impunity. But as you just mentioned, I think it's very remarkable that in the arrest warrants, there were no genocidal charges against any of the Israeli leaders. So noting that, as you have just mentioned, that there has been charges for crimes against humanity of extermination and persecution and also other inhuman acts. So I'm observing now the what's going to come next with a little bit caution, because I was expecting that genocide was going to be included in the arrest warrants, given that we had already the South African case where the court said it was plausible, that South Africa's claims were plausible and that there was irreparable harm to the Palestinian rights not to be subjected to acts of genocide. So I thought there was going to be genocidal charges, and I think that there should have been genocidal charges given the appalling evidence that we have or have been presented to the prosecutor. And I think even though we have, as I just mentioned, and you mentioned that the crime of extermination and the crime of persecution, but genocide, it reflects the reality. It reflects that the Palestinians as such have been targeted.
Right.
So yeah, and as well, it doesn't, the arrest warrants doesn't target those who have been inciting to genocide. So without the genocide charge, we'll not be able to charge who have incited to genocide, because incitement to genocide is an inchoate crime, meaning that genocide does not have necessarily to happen, but the incitement as such is criminalized. So through this crime of incitement to genocide, the ICC will be able to prosecute those who have been responsible for it. So this is my remarks, my preliminary remarks regarding the request for arrest warrants that have been issued by the prosecutor. I'm watching it with a little bit of concern regarding their implications on the ICJ case, the South African case before the ICJ against Israel. And I think that maybe the request or the absence of genocide in the arrest warrants will have implications for the ICJ, and I base mainly my observations or my concerns on the ICJ's approach to International Criminal Tribunal's findings in 2007 when it decided upon the case between Bosnia and Serbia. So in that case, the ICJ, although it explicitly said that to hold the state responsible under the Convention for Genocide, it is not necessary that a specific individual has been convicted for such crime. It said that in one of its paragraphs, but without further explanation. But then further after that, the ICJ has been very, very differential to the International Criminal Tribunal of former Yugoslavia on its findings regarding genocide. So when the ICTY said there was no genocide, there was no genocidal intent, the ICJ said, okay, no genocidal intent. And furthermore, the ICJ also has inferred from the absence of chargements in indictment made by the prosecutor that there was no genocide. So yeah, we know the bench now is not the same, but given the previous precedent before the ICJ in 2007, I wonder how judges are going to react to the absence of genocidal charges in the request for arrest warrants made by the prosecutor. But still, I think the prosecutor made himself clear that this is just the beginning, where there will be, or there might be, additional arrest warrants. So yeah, we'll see from now how it goes. But I think if there is absence of genocidal charges, this might have implications for the South African case before the ICJ.
Those are such interesting points, especially the one about the lack of charges for conspiracy to incite, because I think a lot of people thought that was probably the most easily met of all of the acts in the Genocide Convention, compared to commission. But also the ICJ does have a tendency to do this, where it says, of course, it doesn't matter if the ICTY or if anyone else hasn't, but then, as you said, it played such a hugely deferential role to what they have decided, especially because the rigors of a criminal trial is not something that we're going to see at the ICJ as well.
So no, I think the ICJ has been differential to what the ICTY has.
Yeah. After saying it doesn't have that much of a
it was very, very differential. And I think it was very, very criticized by many scholars.
Okay.
Because they said that the determinative for the outcome before the ICJ should be the availability of evidence, not the availability of judgments from other criminal tribunals. So it will be interesting to see how we bench with in case there are no genocidal charges in the prosecutor's arrest warrants.
Yeah, that will be really interesting. And I think a lot has been made of the fact that he also had a panel of experts, and I wonder what will be made of that going forward. I wonder whether he did it to buttress his case, because it was going to be such a contentious one as well. So talking about one of your most recent articles for Age-Old Talk, you mentioned that while people believe that the ICJ is unlikely to find that there has been genocide committed in Gaza because of the very high threshold of the crime, the ICJ's case law itself holds that this high threshold might not be an impediment to such a finding. Could you just explain the argument for the benefit of our viewers who may not have read your article?
Okay. First to start with, for the listeners, genocidal intent is the unique characteristic for the crime of genocide, because not only does the court have to find that there was an intent to do any of the acts that constitute genocide, but also it has to find that those acts were committed with the intent to destroy the Palestinian population as such, as a national group. So what has been said by most scholars, not most scholars, mainly by a lot of scholars I've been following, is that since the Israeli Defense Forces, they declared that their military objective is the destruction of Hamas, then this will not satisfy the high threshold by the ICJ.
Yeah.
The high threshold which the ICJ puts for saying that there is genocidal intent is that this genocidal intent should be the only reasonable inference that could be deduced from the acts that have been committed. So since we have another inference, then we cannot say that there is genocidal intent. But in my article, I believe that this is an oversimplistic understanding of the ICJ threshold for inferring genocidal intent. And this is mainly for two reasons. The main reason is that it is established in the jurisprudence of international criminal tribunals that genocidal intent can coexist with other motives.
Yeah.
Okay. And the other reason goes back to the nature of genocide. So regarding the first reason, which is that the genocidal intent can coexist with other motives, the jurisprudence of international criminal tribunals has said that the perpetrator can have the motive of destroying the group, but can, with that intent to destroy the group as such, can have other motives as well, whether they are economic, whether they are hatred, etc. Okay, so if we acknowledge this fact that the genocidal intent can coexist with the other motives, then given the threshold which is used by the ICJ, we will never be able to make a finding of genocidal intent, because in all cases there is going to be another reasonable inference.
Yeah.
But so this is oversimplistic understanding for the ICJ standard. So the other reason for not reading the ICJ standard or not understanding the ICJ standard as what has been argued by others is that goes back to the nature of genocide. What is the nature of genocide? Genocidal intent, sorry. Is genocidal intent an intent as such, or is it a motive? So intent is the will to do a specific act. But a motive is the reason underlying doing such act. So if we say that genocidal intent is just an intent, then this is the traditional way of how usually genocidal intent is referred to. But genocidal intent, if we look at it carefully, we will find that it is a motive rather than an intent.
Okay.
So the perpetrator, he kills someone, he kills a group of people because of their nationality, but he does that with the reason of, or with the purpose of destroying them. So here we see that the genocidal intent is the purpose behind doing such act. Okay. So it could be characterized as a motive. Why is that characterization important? Because it is established in the jurisprudence of international criminal tribunals that motives are irrelevant when deciding on the criminal liability of a certain perpetrator.
Right.
So if someone murders someone, it is irrelevant whether he murdered him out of hatred or out of because he was stealing or out of any other purpose. But in the genocide crime, in the crime of genocide, things are different, because here the motive, which is the genocidal intent, is a constituent element of the crime. So we have to look into the motives of the perpetrator in order to deduce whether it is genocidal intent or another motive. And here the court has to engage thoroughly into examining the evidence to deduce genocidal intent. So based upon this analysis in my article, I said that the court has to, in order to apply the standard of the only reasonable inference, it has to examine all the motives of that are reasonably inferred from his acts. And then it has to take into consideration that motives can lie on two levels.
Yeah,
they can coexist, but on two levels. Either the motives, they underlie the genocidal intent, or they coexist on the same level. If they underlie the genocidal intent, then the other motives are irrelevant, and it is the genocidal intent which is the only reasonable inference. For example, a perpetrator kills a number of children, okay? He kills them with the intent to destroy the child population of that group. He's doing that because he believes that those children are going to grow up as terrorists. Okay? So this motive of achieving some military advantage, okay, underlies the genocidal intent.
Right.
So it is irrelevant, and here genocidal intent is the only reasonable inference.
Okay.
What if genocidal intent coexists on the same level with the other motive? Then here the court has to examine thoroughly the evidence to make sure that this coexistence is the only reasonable inference, and that the other motive does not replace the genocidal intent. So through this balanced approach to the ICJ standard, I believe that this high threshold is not an impediment against making an affirmative finding of the existence of genocidal intent in the Gaza context.
Right, and thank you. That was so brilliantly explained as well. And I think it goes to the crux as well of Israel's argument, where they keep on saying not every conflict is genocidal, right? So they're trying to muddy the waters in terms of finding that genocidal intent. No, we are just waging a war on Hamas, not Palestine.
Yes.
Yeah.
Exactly.
Yeah. And just in terms of, we've just seen South Africa go to the court once more for the fourth time now for provisional measures, and again asking for a ceasefire. Do you think that the court is going to be more partial to it now? I think the separate opinions of the last order make me think perhaps. And how do you think that will affect things going on in terms of the Security Council and the potential American veto? Because I know you've written about that as well.
Well, I don't think I have a clear-cut answer to that. I think it's a 50-50, maybe yes and maybe no, but it's a 50-50. But if we look at the last order of provisional measures in March, we will find that seven of the judges, they declared their separate opinions that they believe that the ceasefire is the only effective measure to enforce the order of the 26th of January. So we have 7 judges, but we need the majority of judges. So maybe we need 2 more judges to believe that ceasefire is necessary. And here, maybe again comes the arrest warrant, or the request for the arrest warrants again come into play. Right. But it depends upon how the judges are going to read the request for arrest or the absence of genocidal charges from the arrest warrants.
Okay. Yeah.
Yeah. So they may read the absence as maybe they were wrong from the beginning, that there are reasonable bases to believe that there has been genocide, or at least incitement to genocide. So maybe they're going to be reluctant to engage in a judgment, or to issue a judgment that, not a judgment, an order that calls for a ceasefire.
Okay.
And maybe the judges, they're not going to see it that way. They're going to depend upon the availability of the evidence. So I think it depends upon how the remaining judges are going to see the arrest warrants.
Okay. Yeah. I mean, it will be interesting to see it going forward. I think in terms of how legal scholarship on this has evolved, I think about my own opinion. If you asked me if it was genocide in January, I would have been like, probably not, given how high the threshold is. If you asked me in March, I would say the starvation of civilians can't really lead you to another conclusion beyond Article 2C of the Genocide Convention. And I think that's being reflected also in what the judges are saying. In January, I thought they were going to let in 8. I thought it's a order from the ICJ. It's the easiest one for them to continue with. No ceasefire order, at least let in 8. The fact that they didn't do that in January and now we're in May, my opinion has changed in the course of 5 months of the conflict. Yeah.
Yes, and you reminded me of something when you said about starvation. So now that the arrest warrants, they include also charges of starvation, they include charges of extermination, they include charges of persecution. They might read it as there is a need for a ceasefire, because it is generally acknowledged that starvation, persecution, and extermination, they are stages of a genocide. So there are reasonable basis to believe that, based upon the arrest warrants, that there exist stages of genocide. Even if genocide is not, we're not there yet, but there are basis to be the reasonable basis to believe that that there is a genocide in the making. So yeah, it depends upon how the judges they're going to read also the
extermination one is the most perplexing, I think, for me. Because for me, it's like, what is the difference between extermination as a crime against humanity and genocide? It must be that you don't have any intent to destroy, but you have an intent to exterminate in a widespread and systematic way. I can't quite wrap my head around, is it then just a desire to exterminate on political grounds, which you don't have with genocide? I wonder what they were thinking in deciding to go for that and not for genocide. But it feels a little bit like they just tried to avoid the genocide issue.
The genocidal intent, I think because, I've been told that maybe because the genocidal intent, it proving that there has been a genocidal intent is very hard.
Yeah.
It seems to be hard. Or maybe they are reluctant to engage in this discussion or in this argument now. They need first to put the most obvious crimes where no debates have been going on about. So I think that's why they started with the most obvious crimes, and we'll see how things go later on. But because the difference between extermination and the act of also imposing conditions of life that are calculated to bring about the destruction of a group. The only difference between extermination and this act as a crime of genocide is only the genocidal intent. So I think the prosecution didn't want to engage now maybe into the dispute that has been going on about whether there is genocidal intent or not.
And I also wanted to ask about these declarations to intervene that we're seeing from a few states. I think Nicaragua did it under Article 62, but Egypt, Libya, and Colombia have signaled that they are intervening. I don't think Egypt's application is yet available. Colombia submitted a very, very long application. Libya, a very, very short application, which I don't quite understand what their construction of the convention, of the Genocide Convention is. What do you think? Do you think these are going to really help South Africa's case?
Okay, so first of all, I think that when Egypt is going to intervene, I think it's going to make substantiate the arguments that are going to be made by South Africa, whether regarding to jurisdiction or regarding to the merits of the case. I think Egypt's intervention is also very important in terms of the evidence which is going to be provided to the court, because Egypt is on the border with Gaza. So, and Egypt and Israel since the beginning has been accusing Egypt that Egypt is the one who's not letting in humanitarian assistance in. It said so twice in its hearings in January and the other one in March. So I think Egypt's intervention is going to provide every evidence it have to prove that no, humanitarian assistance was allowed, but it was impeded from the Israeli side. So, but at the end, I'm not sure at the end whether this leads to a successful or an affirmative finding from the court on the merits of the case, because we have seen in the Russian-Ukraine case, the one regarding the Genocide Convention, we have seen that even though 33 states they intervened, but that was not convincing enough. The arguments that they presented to the court was not convincing enough to the court that it has jurisdiction over whether Russia has violated the Genocide Convention by invading Ukraine. So the number of intervening states does not reflect whether or how the case goes before the South Africa, in the South African case. So,
yeah, and I think also because in Russia and Ukraine, all of these states were essentially saying the same thing. Yeah, but I think it would have been very interesting to see South Africa versus Israel if the Gambia versus Myanmar had already been decided. And I think we may have had a lowering of the threshold perhaps there, especially in light of Western countries' declarations of intervention there. And so if we'd had a decision on that, I wonder how differently we'd be taking this case now. We'll never know now, but yeah.
Yes, exactly. Because in the Gambia versus Myanmar case, the Western states, they intervene to support Gambia. And they were pushing forward or advancing a balanced approach to the ICJ standard regarding genocidal intent. So I totally agree with you. It will be extremely interesting to see how things go if the Gambia case was decided before the South Africa.
Because I think now the judges will decide that case, bearing in mind you've got to apply that to Israel. So I think it would have, I'm so interested to see in an alternate universe how that case would have been decided without all of this going on in the background. But thank you so much for giving us your time and your insights. They've been so valuable, and I hope everyone has really enjoyed watching them at home as well. Very interesting perspectives on the threshold for genocidal intent.
Thank you so much for having me, Dr. Aisha. And it has been very interesting having this discussion with you. Thanks so much.
Thank you to everyone watching at home. We hope you'll tune in for future episodes.